Just 2 minutes.
Password or
He's on his way.
no, what is your prayer?
Oh, Passover for the time.
Okay.
God bless.
Item number 11 for supplementary is
11 could be. Next item.
item number 9.
Instead of 9, one more admission. 9 receipt assign. Call 10.
Item 10.
Supplementary team? Yes.
Maybe this one. Lord, we were to file an additional affidavit. We filed the additional affidavit. It's come on record. The documents taken by the investigating officer have also been annexed. I also found the old judgment of this court, my lord, which is placed at, if my lordship has the additional affidavit.
Who is on the other side? State.
State, my lord.
Here, my lord, diary also called for, I think.
Diary was not called.
No, not for.
Diary was not called. It was investigating officer.
Court number 18, item 23, the same matter.
No, that has been, that was released by that court. Registrar found that this was a part-heard matter.
Oh,
So that file is not, 23 is not in that court. The file is here.
so my instruction from office that matter is there.
No. I think
No,
that-
there are some other connected matters.
No, no. What had happened was this matter had come up on 19th. Before this court, my lordship had placed that the affidavit be annexed to the court file. Thereafter, my lord, we made a mention that this matter should be listed today. So also it was shown as listed in court number
18.
18, my lord. So in the morning when I went to court number 18, the file had already been released because it was a supplementary list of my lord's court as a part-heard matter.
No, why it was listed in court number 18?
That
Wrongly,
registry,
sir.
my lord, has done
Wrongly, I think.
wrongly.
Wrongly or
Wrongly.
is there any other connected matter?
No connected matter.
Then we can.
No connected matter. If my lordship has the,
Today, that brief is not with me, my lord. That's I have problem. Any other day, my lord, no problem.
I
a
have,
friend is requesting, what do I do? Because this matter is,
then it will go in the second week of March, third week of March.
third week of March. I think we have been matter is still. Third week of March.
It is routine to exercise.
My lord, if lordship would place it on the 21st of March.
It would be good if it is on some hearing day.
21st of March, my lord.
Okay.
My lordship is, the 14th of March is not acceptable to my lordship. 12th of March also is, it falls in third week of March actually.
Heard Mr. P. N. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor, who prays for an adjournment on the ground that he has not brought the brief of the case today. So considering the ground mentioned by the learned additional public prosecutor, the prayer for adjournment is allowed. Let this case be listed again on
14th March,
no 14th. I will not be
my
there.
lord, 21st.
On 21st of March as part-heard matter.
Deeply obliged. my lord. Thanks.
You have filed the additional affidavit.
Additional affidavit was filed, my lord, on what date? On 7th of February, it was filed, my lord, and it was listed thereafter on 13th February. And then attached to the records, my lord.
Outline, the petitioner has filed his additional affidavit
Filing number.
as per directions of this code by, which was given, no, last line. is right. Find the additional affidavit. Stop it. To Mother Canal. Okay, 21st of March.
Deeply obliged.
I think item number 1.
CD. Yes.
May I please? Well, 439 application. He is a one of the sub-register minor. The allegation is that he has certified one purported forced sale deed minor. He is already interrogated minor. And he was originally arrested in another case minor in Gitanagar police case on 30/12/2023.
In Gitanagar,
In Gitanagar PS case 309/23. Then he was arrested on 30/12/23, and this case he has been shown arrested, my lord. This case also he is in custody for 30 days, my lord. In this case, my lord, the
and since 30/12/23, how many days have lapsed?
62 days he was,
62.
and he was granted bail in all cases, my lord. There are 9 cases against him, my lord.
Nine cases.
9 cases, my lord.
In other cases,
All has been granted bail, my lord. Today, that Gitanagar also granted bail, my lord. The first case. And in this case, my lord, the other accused, my lord, lordship kindly see page page 60, my lord. He was the another sub-register along with me, my lord,
in this case,
in this case, my lord. Page 60, my lord. Your lordship has granted bail to him, my lord. He was custody for 10 days in that case. Then the advocate who certified this fake sale deed, my lord, and who has prepared, he was also granted bail, page 67, my lord.
okay.
And Devashish Borua, he is the extra writer, my lord, of that revenue office. He was also granted bail, page 71, my lord. And my wife is, my lord, recently has undergone, my lord, kidney transplant, my lord. And as per my information, last 1 month, he has been not interrogated, man. Anymore.
Yes, Mr.
Yes, Lordship, we have the diary, my lord. He has been, my lord, thoroughly interrogated by the Ayuk. His statement under section 161 is here, my lord.
Whether you require his
My
custodial
lord,
detention.
all other cases, he has already been granted bail, my lord.
Heard Mr. A. M. Bora, learned senior counsel assisted by Mr. V. A. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Nihendra Thausen, who has been detained in connection with crime PS case number 9/2023 since 31/4/2024.
31/1
31/1/2024. How many days have lapsed in this case?
It's 30, sir. This is 30 days.
30 days in his custody, but in the 409 is there.
No,
90 days, my lord.
no, but the duration till now he has completed
30 days.
30 days. Within bracket for last 30 days. So he has been shown arrested in crime branch PS case number 9/2023 while he was in custody in connection with Gitanagar PS case number 309/2023 since 30/12/2023 within bracket 62 days for last 62 days. Stop. The gist of accusation in this case is
Yes.
court paragraph number 3 from page 61. The allegation against the petitioner in this case is that no, not building this line. You were not originally named in the affair.
No. Page 53,
So
page
that-
53, my lord. His grounds of arrest, my lord, page 53. Page 54. Fourth paragraph from the top, my lord, and the page 54, paragraph 4, during investigation that, accused-
investigation of this case.
yes, Devashish Boru, extra writer, dispute revenue cycle,
During investigation of crime branch PS case number 9/2023. It was found that the present petitioner has what you have done
certified,
has certified a
one purported fake sale, my lord,
purported fake sale deed
dated, my lord, 31/12/2004,
dated 31,
31/12/2004,
which one? Dated purported sale deed dated 31/12/2004 bearing deed number 1096906. Is it the
yes, 10906.
10906? Learned senior counsel for the petitioner has submitted that the petitioner who was initially arrested in connection with Gitanagar PS case number 309/2023 on 30/12/23 has been behind the bar since last 62 days. And today only he has been granted bail in the said case by a coordinate bench of this court. It is also submitted by learned senior counsel for the petitioner that apart from this case, 8 other cases were registered against 8 other cases of similar nature were registered against the present petitioner, And in all the other cases, the petitioner has already been granted bail. Learned additional public prosecutor has produced the case diary of crime branch PS case number 9/2023 and has submitted that when his interrogation was last made and has submitted that the investigating officer of the said case has thoroughly interrogated the petitioner and he was last
First of
interrogated on
February, one
Oh.
to 24.
1st of February 2024. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record, including the case diary of crime branch PS case number 9/2023. It appears that the petitioner, who was also accused in eight other similar cases, has already been granted bail in other cases. And in the instant case also, his statement has already been recorded under section 161 CRPC by the investigating officer, and the investigation has fairly progressed. Considering the fact that the petitioner has been detained behind the bars in connection with this case since last 31 days and within bracket 61 days in total bracket close. And also considering the progress made in the investigation, further custodial detention of the present petitioner does not appear to be necessary if he otherwise cooperates with the investigating officer. Cooperates in the investigation. Stop. Next para. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
CGM.
Chief Judicial Magistrate, Kamrup Metro, subject to following conditions. Condition number 1. With above observation, this bail application is hereby disposed of. Send back the case type.
Obliged.
I apply.
Item number 2, 3 and 4.
Oh. Here 3 connected appeals are there, my lord.
Who is for the state?
State is there, my lord. One appeal against acquittal and one revision against acquittal is also there.
Appeal against acquittal.
Yeah, one is appeal against acquittal by the state and one revision against acquittal by this by the informant in the same case.
Who is for the informant?
Appears to be absent, my lord.
Yes, here, my lord, item number 4, that is, my lord, preferred by the state.
You are for respondent.
In one case, 2 cases I am respondent, in one case I am the appellants, my lord,
In
where 4 person has been convicted, my lord. Initially, there are 13%
why
acquitted,
these are clubbed together? Because of
The out of the same judgment.
same.
arising out of the same judgment, but 13% has been acquitted and 4% has been convicted.
Okay.
And out of that 4%, my lord, 2% already expired, my lord, during the pendency of this appeal.
They are on bail.
They are on bail.
Which matter should we take up first?
Actually, my lord, I am handicapped. 2009 matter, I could not find out, my lord, those papers in our office, my lord.
But you have to find it out.
Yes, definitely, my lord, but today I have no option, my lord.
Then what is to be done?
You can start, my lord, the lordship with permits me,
the-
then I can start my appeal, my lord. You can-
Where you are the appellant.
Yes, there are 4 persons convicted. Out of 4, my lord, 2 has been. Wait, sorry. 4 persons being convicted, my lord.
That is.
Let
criminal case.
this matter be listed next week, because I have to collect the papers, my lord, from court. I have to collect it, my lord.
Mr. Because we will not be able to complete it
Yes.
and it will become part of.
Um,
Heard, Mr. A.M. Bora.
Informant is also absent, my lord.
Learned
that-
sen- Yes, Learned Senior Counsel assisted by Mr. V.A. Chaudhary, Learned Counsel for the Learned Counsel for the appellant
I
in criminal
have
appeal number
to then-
16/2019.
এটা ফর্ম পূর্ব কালেক্ট করে দিতে হবে। যদি তোমার মুটুটু না থাকে না মুটু চলে গেলে
This appeal is tagged with criminal appeal number 17/2000, criminal appeal number 79/2009, and criminal revision petition number 101/2009. However, in criminal revision petition, no one has appeared.
She's indisposed of, my lord.
The petitioner's counsel has not appeared. Is not present today. On the other hand, learned additional public prosecutor, Mr. B.B. Gogoi, has prayed for an adjournment on the ground that he has to trace out the connected papers of the cases which are listed today. Considering the grounds mentioned by the learned additional public prosecutor, the prayer for adjournment is allowed. Let this matter be listed after 2 weeks. After 2 weeks.
Right.
Question number 5.
Lordship, may it please, Lordship. Lordship, in this matter, I am seeking.
Mr. B.M. Chaudhary, you are also representing someone.
Yes. I'm also there with Mr. A.M. one.
Okay.
Lordship, in this matter, I am seeking, praying for an adjournment, Lordship.
Which one?
Item number 5, Lordship. If the brief has been misplaced, I don't have the brief, Lordship, I have to reconstruct it.
In all old cases, briefs are, you have to,
But
when will you locate it?
Lordship, I have to reconstruct, I have not found it after 2 weeks, Lordship. I have to get the certified copies, Lordship.
Heard Mr.
C. Sharma, Lordship.
C. Sharma, learned counsel for the petitioner, who prays for an adjournment on the ground that he has misplaced the brief and needs some time to trace it out. Considering the grounds mentioned by the learned counsel, The accommodation is granted. Let this, the adjournment is granted. Let this case be listed again after 2 weeks.
Obliged, Lordship.
Item 6,
Wait, please, your lordship. This is a matter pertaining to default in payment of the provident fund dues by the tea company.
Just a Two 2011, yes, yes. You are Mr. A.K. Chaudhary.
Yes, your lordship.
Yes,
This is with regard to the FIR being lodged, that is at page 27, annexure 3. With regard to the default in payment of the provident fund dues.
you are seeking,
We
Quashing
are
of-
seeking the quashing of this FIR. That is annexure 3. The informant is the respondent number 2, the fund control officer of the Assam Tea Plantations Provident Fund Pension Fund Scheme. And your lordship, may I just draw your lordship's attention to page 28, the FIR.
yes,
I am to inform you that the employers of Craig Park Tea Estate in the district of so-and-so have failed to deposit provident fund contribution amounting to 26,63,000 and odd. Only for the period with effect from 1/11/06 to 5/2/2011, containing 51 numbers of Form 1 duly attested submitted by the garden management. As Section 2 of the Assam Tea Plantation Provident Fund Scheme Act 1955 as amended, every employer shall be responsible for collection of provident fund contribution from their employers. Their remittance as per provision laid down in para 24 of the Assam Tea Plantation Fund Scheme. But the employers of Craig Park Tea Estate have failed to deposit the collected provident fund contribution, though it has been deducted from the wages of the workers. Thus, the employers of Craig Park Tea Estate have committed a serious offense like criminal breach of trust and misappropriation by not depositing the collected provident fund contribution and their matching contributions, such as so-and-so, the petitioner number 1, and the petitioner number 2, the Ranjit Kumar Nath, the manager of the said tea estate. Under so-and-so and liable to be prosecuted on penal provisions of law within the meaning of section 403, 405, 406, 408, 409. On that basis, this case was registered as Katigora PS case number 437 under section 406 and 34 IPC. Now, your lordship, since the business of the company was not doing well because the prices of the tea was falling and the input cost was resulting in huge acute financial loss. So your lordship may kindly turn to annexure 1, which is at page 23. Page 23, annexure 1. We wrote to the authorities.
page,
Page 23. I'm just coming to the background. Why we defaulted in payment. And we wanted subsequently some accommodation from the authorities, saying that give us some time and we'll able to make the payments. Subject is delayed deposit of PF dues and current provident fund contribution.
what is this page 23?
Page 23 is a letter from the petitioner's company,
To the PF, to the,
to the chairman of the office of the board of trustees
Assam Tea Plantations Provident Fund and Pension Fund Scheme and DLI scheme. It has been forwarded through the additional Provident Fund Commissioner at Guwahati. With reference to your letter dated, there was a letter. We are grateful to your honor for allowing us a chance of hearing on so-and-so 9/9/2010 on the subject cited above. Hereby, we are submitting the undernoted documents as above. Sir, most humbly and respectfully, I would like to place a few points before your good self for your kind and sympathetic consideration. Sir, we like to draw your kind attention to the unprecedented crisis being faced by the estate due to the falling price of tea on one hand and rising input cost of essential commodities such as fuel, electricity, petroleum products, fertilizer, ration, wages, staff salary, etc. have gone on increasing. Over and above this, garden has suffered from drought, even uneven distribution of rain for rainfall, storm, for which there was fall in production considerable. In view of the above reasons, the company is facing acute financial crisis to the extent that we are not even sure to meet up the wages, our wages and ration requirement in time. Under the above circumstances, view to consider our case and will request your good self not to impose any damages for delayed payment. Now that is very important. Kindly allow us to deposit the due amount in monthly installment basis at rupees 50,000 only. So thereafter, what had happened, this Annexure 2 follows. With reference to above, that is from the Secretary cum PF Commissioner to us, he writes to the company. With reference to above, I am directed to say the Honorable Chairman Board of Trustees, the first letter that we had addressed to the authority. After due personal hearing of your representation and in consideration of all facts and circumstances and your written representation dated so-and-so has been pleased to pass order as follows. The priority basis the PF dues of seized members up to the date of cessation as and when arises, submit and required requisition, if any, to their respective zonal. I'm not getting much into it. I'm just getting to the point number 3. To deposit the arrear uncovered PF dues, because that is the amount also that related to the FIR. Amounts of so-and-so payable for the period of 5/11/2006 to...
This was allowed.
This was allowed. Thereafter, subsequently, what happened? Pursuant to that.
The period mentioned here is
Same.
Same,
period
I think-
mentioned in the FIR.
Yes,
Yeah.
your lordship.
Okay.
Then subsequently, your lordship will kindly turn to page 4, paragraph 4.
Paragraph 4.
Yes, your lordship.
Yes.
Page 4. Now, paragraph 3 deals with that Annexure 2, the one that we have referred to. That acting in pursuance thereof, the petitioner.
No, where are you reading?
Paragraph 4, page 4.
Page 4.
4 of the main quashing petition. That acting in pursuance,
Just a-
where the lordship has got. That acting in pursuance thereof, the petitioner has been regularly depositing the Employees Provident Fund contribution in the state Assam Tea Plantations Provident Fund through State Bank Silchar. The details of the aforesaid payments. Now here are the details that we have made the payments. We literally could not make the payment as assured, of 50,000, but then substantially we have made some payments. That meanwhile, paragraph 5 is also important. That meanwhile, the respondent number 2.
This
fund-
payment is the part payment.
Part payment.
Okay.
It is not a full payment. That meanwhile, the respondent number 2, Fund Control Officer, the Assam Tea as informant, file an undated first information report before the officer in charge, Katigora Police Station. Now thereafter, this FIR comes, the one that I had read previously, Annexure 3.
Yes.
Now what happened thereafter? Again, we make some payment. In paragraph 6, we have stated an amount of rupees 5 lakhs was made payment. Paragraph 6, page 6. And there was a request also to made to the authorities to kindly withdraw the Katigora Police Station case before starting of the trial. Paragraph 5, paragraph 6, amount of rupees 5 lakhs was paid. Then paragraph 7 also, your lordship will kindly note. We make another amount of 5 lakhs payment. And the authorities issued a certificate dated so-and-so, 9/11/2011 for an amount of 12
4,
lakhs.
6 and 7 you made part payment.
Pound payment. The annexure 4, page 31, your lordship would kindly turn to that page 31. Is the certificate issued by the authorities. Page 31, annexure 4.
Yes,
This is to certify that the management in respect of so-and-so TSA under so-and-so district has deposited 12 lakhs against FIR amount of so-and-so payable for the period. Now, this period is also very important and assured to clear the balance dues within April 2012. Now, this is regarding the facts of the case, your lordship. Now, coming on to the merit of the case, your lordship will come to paragraph 10, page 8. Before that, may I take your lordship's attention to page 8. We have inserted some of the provisions of section 7, which relates to the penalty provisions. Section 7 of the Act 1955. Now, that relevant portion will be in page 8, your lordship. Section 7(2). A scheme frame under this act may provide that any person who contravenes or makes default in complying with any of the provisions thereof shall be punishable with imprisonment for a term which may extend to 6 months or with fine or may extend to 1,000 rupees or both. Have your lordship been able to
yes.
that insert? Then next section is important, subsection 7(3). No court shall take cognizance of an offence punishable under any such scheme except on a report in writing of the facts constituting the offence made by an inspector with the previous sanction of such authority as may be specified in this behalf by the state government. Now, in paragraph 10, we have referred to paragraph 24 of the scheme 1968. Which envisages the procedure for collection of the amount. Now, in this regard, I am just referring to line number 4 of that paragraph 10, page 8. The employer under para 24E of the aforesaid scheme 1968 is required to submit a statement in form 1 to the Board of Trustees in respect of collection of contributions, made collection of the contributions of the employees within 1 month of collection. Now, this is the provision that we have quoted. The relevant portion will be page 9, serial number E. Next page, your lordship. A, B, C, D, E. A statement in form 1 shall be submitted by the employer to the board with a receipt for the deposit made in accordance with D above within 1 month of collection of the contributions. Now, on the legal submission that I am to make before your lordship, this paragraph 11 is important.
Paragraph E,
Paragraph 11. 11, page 10. That your petitioner state that the respondent number 2, so-and-so, by lodging the first information report against the petitioner, sought to evade the protection given to the accused person in section 7 of the Act 1955 for alleged violation of the law. The Act 1955 is a special act under the statute providing for punishment with imprisonment or fine or both to the defaulters who contravenes or makes default in complying with the provisions of section 3 of the Act 1955. In fact, section 7(3) of the Act punishes that no court should take cognizance of an offence punishable under any such scheme except on a report in writing of the facts constituting the offence made by an inspector with the previous sanction of such authority as may be specified on this in this behalf by the state government. Admittedly, no such report in writing by an inspector was submitted to the court in the present case with the previous sanction of the prosecution from such authority of the state government was obtained for taking cognizance of the offence alleged. Now, according to us, this provision of section 7(3) of the Act 1955 was deliberately bypassed by resorting to section 406 by coming to the first information report under the penal provisions of the Indian Penal Code.
okay.
Secondly, your lordship, paragraph 12, where we have come, that section 406 read with section 34 relates to alleged default in payment of provident fund contribution violation of so and so and scheme. Now, in this regard, we want to submit section 771A and 72 of the Act provides a maximum punishment of 6 months or with fine, which may extend to rupees 1,000 rupees or with both for avoiding payment to be made under the Act. Now, on the other hand, the maximum punishment provided for commission of offense under 406 is 3 years or fine or with both. So that's a harsher punishment for us. So the authorities concerned, by bypassing the provisions of the beneficial legislation of the Act 1955, sought to penalize us with a harsher provisions of the penal code. That is one of the reasons. Secondly, in paragraph 13, we have said about the limitation under section 468 CRPC. The period of limitation here in our case is that 6 months if the offense is punishable with fine only. 1 year if the offense is punishable with imprisonment for a term not exceeding 1 year. Now here, your lordship, if your lordship says that they have surpassed this provision because the punishment given here is 6 months or fine or with both. Now here they have come with an FIR on a much later date. So that is why the section 468, there is a bar on the.
No, bar as regards the offense under the Act,
Yes, your lordship.
section.
7.
But not, Or
Maybe not
406.
under 406, maybe not under 406, subject to correction, your lordship.
Okay.
That is one area. Secondly, your lordship, no, I'm making I'm reading the paragraph 16 of page 13, your lordship. That your petitioner states that similarly, even if the petitioners are sought to be prosecuted under section 7 of the Act 1955, the said prosecution would be barred by limitation as provided in section 468 of the Code of Criminal Procedure, in view of the fact that maximum punishment provided under section 7 of the Act is only 6 months. Just now what has been put on record. Then secondly, your lordship,
no, but this case is not under section 7.
that is true. That is true. That is why saying that we have taken the plea of doctrine of circumvention also. They have tried to circumvent the laws, the special law, the statute that is in force, bypassing it, and they have gone for the penal provisions to prosecute us. Thirdly, your lordship, this element of mens rea is also not there, because we never wanted to default or we never went out of the picture. We wrote to the authorities, we have expressly written to the authorities concerned that these are the various difficulties we have faced. And on this count alone, the authorities may take a liberal view and may allow us. Even if we are granted 50,000, the authorities are very kind enough to grant that accommodation. But despite that, on record, it is admitted that we have not been able to make 50,000 or above and above. It was only after much later that we could make the payments of 5 lakhs and the various amounts that were made from time to time. Now, besides this, your lordship, the instruction that I also have is that subsequently, we have made the payments.
Of the entire amount
Entire amount.
mentioned in the FIR.
Yes, your lordship. There's an communication also from the authorities. Your lordship would consider the highlighted portion, serial number 4. FIR lodged for period 05/11/06 to 05/02/11. Now, your lordship will kindly come to page 28 of the quashing application, the FIR portion. That period also tallies with us. And whatever outstanding payment was there, we have made the payment. So as on date,
In FIR only period is mentioned.
yes, that is what the amount subsequently they have
Amount
raised
is-
that we have failed to deposit the balance amount that was also paid.
Amount is also mentioned.
Amount, your lordship will kindly come to the
56.
left side of the column of that serial number 4A.
Yes.
The balance is nil.
Okay.
The amount also tallies 26 lakhs 63,682.12. Now that balance is also nil. So apparently that FIR alleged amount was also deposited.
The 406 is compoundable.
That of course. But we are taking we are taking recourse to section 7. So on that view, because since they are trying to circumvent the special law.
You have any authority on doctrine of circumvention?
Yes, your lordship.
Okay.
We have already put on record. Please refer to yes. Page 12, your lordship. Page 12, paragraph 14.
Okay, you have mentioned here.
You have mentioned.
Okay.
Only thing, lordship will have to accommodate sometime so that I can place those judgments. Today, at this moment, I am not in a position to.
Okay, not necessary. We will find it out.
Hmm.
But relevant paragraph you can point out.
Yes, your lordship. AR 1953, then AR 1966, 1969, and there's one Guwahati High Court case, which is also equivalent to 1992 GLR NOC page 48, the last one, this 89 judgment of Guwahati High Court. Hari Prasad Agarwal versus State of Assam.
You may mention the relevant paragraphs on which you are relying.
And your lordship, we had also filed a similar matter before the High Court. And the Honorable Court, this High Court, by judgment dated 21/5/2020, had have allowed the petition. It was also similar on this, like default in payment of. Only thing probably it was not reported in any of the local journals. It was during the COVID times when the COVID was actively. Mahendra Kumar Agarwal.
Yes.
Well,
Yes, Siddharth.
I will leave it to lordship because since the petitioner has already deposited this amount, my lord, mentioned in the FIR, that is also reflected in the letter also, my lord. But only, my lord, this interest, my lord, the interest part for delay in depositing the contribution, my lord, that part of this that comes to rupees 12 lakhs 27,028. That has not been deposited, my lord.
But
But for that, this
that-
criminal case would not.
Well,
because
Well-
even that amount is also not part of the FIR amount.
no, that is
Is subsequently they have evaluated it.
but there is the delay in depositing the amount. What happened in this case, my lord? Not only the petitioner, my lord, defaulted in depositing the contribution of their own contribution,
How
but they
much
have also
interest?
defaulted.
How much interest?
At the rate of, my lord, that mentioned, my lord, 15% statutory interest on delayed deposit against period from 5/11 to 2006 to 5/2/2011 comes to rupees 12 lakhs 27,028, my lord. Well, in this case, actually, this FIR was first only just to give us some pressure to the petitioner for depositing the PF amount, my lord. After all, they have already collected the PF contribution from the employees, but that was not also deposited.
No, even if suppose assuming that their petition is allowed,
My lord.
it will not absolve them. from-
Exactly.
No, madam, no, madam. That
Exactly.
we can proceed, my lord.
Yes,
Then you can proceed, madam.
they can always take recourse to the provisions of the act or the scheme to realize that amount as on date.
Anything,
That yes, I leave it to you, lordship, my lord.
observing, heard Mr. K. Chaudhary,
AK chose
A.K. Chaudhary, learned counsel for the petitioner, also heard Mr. N.C. Das, learned senior counsel, assisted by Ms. G. Bush, learned counsel for the respondent. Hearing concluded, judgment reserved.
In the meantime, I'll furnish the copies.
Mention the paragraphs.
Let
Published
this
well.
copy of the communication that we have received from the authorities may be made part of the record.
Actually, that is there.
On the learned counsel for the petitioner has submitted its statements.
It can be referred to as a statement by the authorities or additional public.
Statement of deposit position of PF contribution in respect of the petitioner's company. Let the same be kept in record as a part of the
Right.
case.
It was issued by the authorities.
That we have.
Down below the seal and signature is there. referred.
It's our document.
Yes.
It is issued by you,
My lord.
issued by the respondent authorities. Let the same be part of the case.
That is dated 28th of March 2013.
Mention the date also.
Whether your lordship will be requiring a copy of the scheme Act 1955.
It would be good if. it-
Yes, that is why.
Ekon did you?
Ekon,
Okay.
Ekon.
You can take it back after.
Obliged.
Obliged.
Item 7,
May I please, your lordship? This is 2011 matter, lordship. Brief is also it has lordship. And my senior also is out of
You
station.
have to find out briefs.
Lordship,
It may be misplaced, lordship.
Now, what is your prayer?
Lordship, I have not instructed by my senior, lordship. My senior is also out of station.
even I had to, Lordship, I am appearing for the Corporation Department. Our name has been shown in the cause list.
Lordship,
And,
only my senior name is reflected in that cause list, lordship.
Because we are not made a party here, your lordship. I also took out from the registry only a copy of the petition. Item 7. Neither in the complaint petition, our name, we are a party, nor in the criminal petition, your lordship. But our department name is shown in the cause list, your lordship. This is, the petition is filed by Drive India Enterprise Solutions. Respondent Satyajit Kalita. And I was just checking the E-code service, your lordship, and it is shown that the original complaint has also been disposed of in 2015 itself.
At least petitioner has to be ready.
Yes, your lordship. Only,
There may be some judicial order making you. Otherwise, why your name has been,
lordship. Otherwise, we are not a party, your lordship.
there is only one opposite party.
Yes. And even if your lordship sees the complaint, that is at page number. Even 17.
There also you are not,
There also we are not a party.
what is your name?
Lordship V Rajkoi.
You are Mr., you are with Mr. H.R.A. Chaudhary.
No, your lordship, I am for the corporation department. Because in the cause list, our name is shown. Standing. HRA Chaudhary is also shown as respondent.
Respondent.
Yes, I am also shown as respondent. Private party asset. Private party asset.
Standing Council Cooperative Department has been shown.
Respondent or has it?
Heard Heard Miss, what's her name?
Arden.
Ardeka, learned counsel appearing for the petitioner. Also heard Mr.
V Rajkoi.
V. Rajkot, Standing Council Cooperative Department.
Corporation. Corporation, your lordship.
It is
Corporation.
Corporation or cooperative?
It's corporation.
Corporation
Corporation.
Department. Now, Mr. Rajkot submits that the name of the Standing Council Corporation Department has been shown in the cause list. However, they are not a party in this case. The registry to verify the record and put up the case record again with an appropriate office note. And if it is found that put up the case record with an appropriate office note. Miss R. Deka, learned counsel for the petitioner, also prays for some R. Deka.
Yes.
Said, HRA Chaudhary,
Yes.
respondent is.
Lordship,
Mr.
our
for
senior name is reflected in respondent.
Okay.
Petitioner, it is showing Mr. S.K. Medi and.
None,
Mr.
no,
Arsan.
none has appeared for the petitioner on call. Miss R. Deka, learned counsel appearing for the sole respondent has. No, then this is not required. Cancel it. I'm dictating it again. Mr.
V.
V.
Rajkoi.
Rajkot, learned Standing Council Corporation Department has submitted that their name, the name of the Standing Council has been shown in the cause list. However, they are not a party in this case.
Gotcha.
Their name shall be deleted from the cause list
Gotcha.
henceforth. On the other hand, none has appeared for the petitioner on call. Ms. R. Deka, learned counsel appearing for the sole respondent has also prayed for some accommodation on the ground that this is an old pending case and the brief, they could not trace out their brief and prays for some more time to trace out the same. Considering the circumstances, this case is adjourned for today. Let this case be listed after 2 weeks.
Obliged, Lordship.
Lots. Bye-bye.
Item number 9.
May it please your lordship.
Yes. Yes, Mr. Man, your part is over.
Yes, my lord, I had concluded my submissions, my lord.
I thought you would start again today.
No, not at all, my lord.
Yes, Mr. Halloy.
Lordship. Lordship, regarding the facts of the case, I think Lordship is clear. Allegation is very clear that some employees of National Highway Authority of India, they in conspiracy with GR Infrastructure, they used to demand illegal ratification for passing of the bill. And the specific allegation against this person is that Alok Kumar, being the head of National Highway Authority, he, in connivance with his officials and the officials of GR Infrastructure, helped the GR Infrastructure to pass the bills as well as the bank guarantee. That is the allegation, which is clearly reflected in the FIR as well as in the charge sheet. And thereby, he procured the job of his cousin, first allegation. Secondly, he demanded 50,000 rupees from one Manoj something, he's a witness to this case, for selling a VM plant, which is the,
No, whether that allegation was there.
that allegation is not there, but Lordship, during investigation, statement of witnesses come on record.
No, their submission is that you can investigate if it is not a case of bribe. Then you can investigate only after taking prior approval under
I will
17.
satisfy your Lordship on that one. 17A, with regard to the allegation, Lordship is clear. These are the two allegations, specific allegation, which has come on record. Now regarding 17A. What is 17A, Lordship? (17A) is with regard to the taking of prior approval. When prior approval is required, 17A is very clear. When the alleged offense is relatable to the recommendation made or a decision taken by a public servant in discharge of his official duty. That is the reading of section 17A. So two things we'll have to satisfy, that the offense, what is the alleged offense, and the relationship with the offense with the discharge of his official duty. And what is how we have to discharge? He'll have to either recommend or to have to take decision. These are the two criteria. He'll have to the public servant will either have to recommend or to take decision in discharge of his official duty. Now here in this case, whether the accused petitioner has recommended anything, firstly, whether he has taken any decision with regard to the case, the answer is no, Lordship. Here in this case, he simply approved with regard to the passing of the bill. My learned friend has already shown the noting where it is clear that he has approved. He is not recommending that so and so bill must be passed. So and so it is my decision. I have taken a decision, solitary decision that so and so will be bank guarantee should be released. It is not like that. Decision has been taken by someone else. And moreover, Lordship, passing of bills and releasing of bank guarantee cannot be regarded as a decision taken, Lordship. It is clear from a judgment, Lordship. I am placing a judgment. I'll read it, Lordship. Yeah. Lordship, it's a judgment of Kerala High Court, Lordship. And moreover, it's a taking of bribe, Lordship, illegal gratification. Lordship, may I read the judgment, Lordship?
Now, before that, let us once again. Where the alleged offense is relatable to any recommendations made
or decision
taken by
public servant
such public servant in
in discharge of his official
his
duty. Now, whether taking bribe will amount to discharge of his official duty, whether demand of bribe can be regarded as a work done in discharge of his official duty, there are several Supreme Court decisions where it has been stated that it is no, Lordship. Demand of illegal gratification cannot be regarded as work done or an act done in discharge of his official duty, Lordship. Likewise, criminal conspiracy.
This allegation of taking rupees 50,000 for selling
VM plant, a plant, Lordship, it's a machinery which belongs to GR Infrastructure. That the plant.
That was not the allegation. That was
not there in the
according to you was found during investigation.
Yes. that lordship, in the during the time of framing charge, those things will come into account, lordship.
What was the allegation?
The allegation in the FIR is that all these accused person of NH Highway Authority, they in connivance with the GR officials of GR infrastructure, they used to take illegal gratification. They are demanding money for passing of the bill, for smooth passing of the bill. And lordship, specific allegation against Alok Kumar is that he took undue advantage for securing the job of his cousin, lordship. That is the specific allegation against Alok Kumar.
For which he delayed the
Delayed. Now,
the
yesterday,
disbursement of
yes,
second part of the
yes.
case.
Now, yesterday, they have shown a paragraph where it has been stated that agreement was shown that within 60 days, they need to release the bank guarantee. And as because the contractor, they have sent a letter on 6/6 dated so and so, and therefore they passed the bank guarantee on 8/6, as because they received the letter of the contractor on 6 regarding the defects and liability. On 8, the Sushil Kumar, who is an employee of NHA, he forwarded a letter through internet to Alok Kumar, and Alok Kumar immediately within 24 hours has released, approved it. So why don't they take this process before the stipulated time? Stipulated time is, lordship, 60 days is 31/5/22. Within that, work was completed on 31/3/22. 60 days period, maintenance and liability period 60 days. That is 31/5/22. Within that period, they ought to have undertake this process regarding if there is any defect. Write to them. They are silent. Altogether, they are silent. NHI authority of it, employees of NHI. They are silently sitting, and ultimately, in order to fill up the lacuna, what did they did? There's a conspiracy. Therefore, they send a letter. The contractor, they send a letter on 6 after completion of this period, 31/5/2022, on 6/6. This process they ought to have carried out before 31/5/2022. Nowhere they have stated that yes, this accused petitioner has taken initiative, wrote to so and so to place such application. They have not shown any document. There is nothing as such, lordship. There is a conspiracy between Alok Kumar, Sushil Kumar. Intercepted calls are there, lordship. All these things comes out from the intercepted call, lordship. So after going through those intercepted call, trap was laid, and on trap, lordship, these accused were apprehended. On 13th, Sunil Kumar Agarwal and Pankaj
But they
Sharma,
have not named the present petitioner.
they have name, lordship. In the FIR, clearly there was a name.
The two employees who have been apprehended.
They were named, lordship. Subsequent in their statement, if your lordship sees their statement.
They named Alok Kumar.
Yes, lordship. In their statement, lordship, when their statement was recorded. That Alok Kumar also used to take legal gratification. Your lordship calls for the record and sees the statement of the accused, this accused person, clearly transparent, lordship, that Alok Kumar is a party to it, lordship. Now, lordship, with regard to that letter, I'm clear, lordship, that there is no communication from Alok Kumar to the contractor within that stipulated period, 31/3/22 to 31/5/22. Within that period, he ought to have taken steps. If there's any defects, there is nothing. They are silently sitting over the matter for releasing the bank guarantee.
Between
31/3/22 to 31/5/22. That is a 60 days period.
now, what is your submission?
My submission is that during that period,
Huh.
60 days period, Alok Kumar ought to have right to the either Alok Kumar or the authority or the other employees like Sushil Kumar Verma and all who are the employees of NHI. They ought to have wrote to the contractor that see this is the defect, this is the liabilities. You whatever you want to say, you just submit to us. There is no communication as such. Why they are sitting silent within that 60 period? 60 period.
No, but who has to identify the defect? The authority engineer.
Here, authority in there, authorities in there are silent on lordship, authorities engineer.
Authority engineer will
On
verify
27
and he recommend.
He recommend on 27/5/22. Why they are sitting silent over the matter? 27/5/22 authority engineer wrote a letter to NHI stating that you release the bill. but they took that letter otherwise. They thought that it was not recommended. So therefore, they put their all effort talking to the authorities in India that don't write all these things because it will create hurdle to us. Authority engineer wrote to NHI on 27/5/2022. Subsequently, another letter come from authorities under pressure of these two accused persons, Alok Kumar and Sushil Kumar Verma. And therefore, authorities subsequently wrote. Therefore, Lordship, the stand taken by the accused petitioner that they are not arrayed, there is no role played by them, is completely misleading, Lordship. That about, Lordship, may I read the law with regard to the 17A, Lordship?
Yes.
Para 7, one of the earliest decision of
Which just
judgment, Lordship. I'll give you a judgment, Lordship. I've taken only one copy.
you
This is a judgment of
citation?
it's at Kerala High Court, Lordship. Here, Lordship, the Kerala High Court discussed some judgment of Honorable Supreme Court also. And Devendra Kumar, Lordship, where 17A was not referred even then, Lordship, 197 as because the procedure is same, Lordship, regarding sanction and approval. Act done in discharge of his officiality. What is the act? What are the acts which can be regarded as an act done by an official duty? That is there in Devendra, which is Supreme Court ruling, Lordship. Now, I am referring to, Lordship, a Kerala High Court decision, Lordship. Paragraph 7. I'll place one of the earliest decisions of the Supreme Court on this point was in Baijnath Gupta and others versus State of Madhya Pradesh. The question that came up before the Supreme Court was whether a public servant charged with offence punishable under Section 477A, read with Section 109 and 409 IPC required previous sanction from the competent authority as contemplated under Section 197 CRPC. Supreme Court referred to two earlier decisions in the Holiram Singh Emperor versus Emperor, as well as a decision reported in H.B. Gill and others. In the latter case, the accused was charged under Section 161 of IPC with taking bribe, and under Section 220B IPC with criminal conspiracy. On the question whether sanction was necessary under Section 197(1) CRPC, it was held by the Judicial Committee that there was no difference in the scope of that section and the one under Section 270 of the Government of India Act. In Horiram's case, Supra, it was held that the public servant can be said to act or purported to act in discharge of his official duty if it was such as to lie within the scope of his official duty. Thus, act of a judge receiving bribe, though the judgment which he delivers may be an official act, taking bribe does not become an official act. So taking bribe, here also undue advantage. The act done by the public servant is undue advantage. Whether taking an undue advantage amounts to an act done by a public servant in discharge of his official duty, answer is no, Lordship. The principle is that. It was also held that the government medical officer does not act or purported to act as a public servant in picking the pocket of a patient whom he was examining, though examination itself may be such as an act. The court laid down the crucial test as to determine whether a public servant act or purports to act in the official capacity by holding that, if challenged, he can reasonably claim that what he does was by virtue of his office. Now, Lordship, what is official duty? In paragraph 10, it was reiterated. In the state of UP versus Paras Singh, the question that arose was whether sanction was required for prosecution of a public servant charged with Section 409 and 468 of IPC. It was held that by use of expression official duty implies that act or omission must have been done by the public servant in the course of his service, and that it should have been done in discharge of his duty. It relied upon the decision
No,
of a
here the 17A says that the offence must relate to a decision taken
or the
or
recommendation.
a recommendation
Yes.
made.
Suppose, Lordship, for instance, Lordship, if some tenders will,
No, here the decision to release bank guarantee.
where is the decision, Lordship?
The note was put up before him
He has
where
approved.
that is the decision.
If we take that interpretation, Lordship. Every trap cases, Lordship, where the files were moved, I am taking an official employee while executing a file, Lordship. He is taking bribe. That is also a decision, Lordship. Every cases which are tried in trial court, every cases will.
No,
follow.
here the
I-
allegation is not of taking bribe.
Not, I'll read, Lordship. It is clearly stated, Lordship. Accused of something to do must related in some manner, Lordship. I'll skip off, Lordship. I'll directly come. Para 14, no doubt,
Okay, before that, one thing you have to make.
Lordship.
What are the allegations? Three, police, he took 50,000.
50,000, Lordship.
50,000 for DM.
For selling of a DN plan. He
DM
demanded
This you find out during investigation.
during investigation.
And when you started investigation, what was the allegation?
When we started revision, he in connivance with other employees of NH Highway Authority who were arraigned as an accused in this case, along with the employees of GR Infrastructure, they used to pass the bills. There is no decision as such taken. Pass the bill.
Pass the bills.
Pass the bills for smooth passing of the bills. No decision, Lordship. For smooth passing of the bills. No decision as such, Lordship. It is the project director who is required to pass the take decision for releasing of the bill. It is regarding the passing of the bill. Will help you to pass the bill. The Sunil Kumar Verma and Alok Kumar, they are helping the GR Infrastructure and they are demanding different. Sunil Kumar Verma's demand is different. Alok Kumar Verma is different. Everyone.
What was the allegation against him?
Against whom, Lordship?
Alok Kumar.
Alok Kumar is this, Lordship.
He will pass the bill.
He will help the accused person to pass the bill.
In
And
lieu of what?
in return, Lordship, the service of his cousin first.
Service of his relative.
With procure for securing the job of his cousin, he is helping. That is clear from the telephonic conversation, intercepted call.
No, but in telephonic conversation, he does not say that unless you.
No such Lordship. I have already made my submission on that point. He is a regional officer. Not only he, nowadays, Lordship, whether an officer will demand like that. Nowadays,
No,
Lordship. they are
otherwise,
very
how will
intelligent.
you implicate him? Suppose he speaks to, just I am putting a
Lordship.
query.
Lordship,
Suppose his relative has applied
Lordship.
and he says, Dekh lena.
Hmm.
Like
What?
this kind of words he has used. Will it mean that unless you see to it, I will not release your bank guarantee?
Lordship, what is the duty of this RO?
When,
Lordship, let me give an example, Lordship.
no, you explain it in the context that the note for releasing the bank guarantee was put up before him
On 8,
on
on
8.
8/6. 8/6 2022, Sushil Kumar Verma, manager.
Yes, 8/6 at 5:46 PM.
4:49 PM, Lordship. Or Sunil Kumar Verma has put up this. And Lordship on 8/6/22, Anantalal. It is Anantalal, Lordship. Anantalal, PDPIO Haflong. It is his duty to execute the bill and all. Sunil Kumar Verma is no way related to all these things, Lordship. Sunil Kumar Verma is no way. Sunil Kumar forcefully, he entered, he executed. And there is a clear communication between Sunil Kumar Verma and Alok Kumar Verma regarding the release of the bill. I placed intercepted calls are there, Lordship. Sunil Kumar Verma has no role to play with regard to passing of the bill, Lordship. He is a manager, Lordship. It is Anantalal, Project Director, PIU Haflong, Lordship. He is the authority. He need to forward the bill to Alok Kumar, Lordship.
No, but the submission was that the project director forwarded on 8/6/2022 at 5:46 PM.
Exactly, Lordship. Project Director, but where from Project Director? Project Director has received from Ashok Kumar Verma, Lordship, prior to that, Lordship. That on 8/6, Lordship, just above Anantalal. Sushil Kumar Verma. He put up the record, Lordship, regarding the passing of the bank guarantee, attachment for release of
And
the,
his defense was within a day, he cleared the bill.
yes, Lordship. Regarding withholding, I already explained, Lordship. They are saying that on 6/6, the contractor, they submitted some application on 6/6. This one, on 6/6, note number 3. This 6/6 note, 6/6/23, Lordship. 6/6/22, Lordship. Page number 20, Lordship.
Page number
20, Lordship. Page number 20 of my documents, Lordship. Evidence against Alok Kumar. Evidence against Alok Kumar, Lordship. Evidence against Alok Kumar. I've given a bunch of documents. Yes. Page number 20. They are relying on this paragraph. With your Lordship got it. They are relying on that note sheet number 3. Note sheet number 3, they are saying that contractor's letter number so and so, authorities in the letter dated 6/6/22. As because the contractors has submitted a letter on 4/6/22 and the authorities engineer letter on 6/6/22. Who made the authority engineer to write this 6/6/22 letter, Lordship? It is Alok Kumar, Lordship. I've shown the telephonic conversation, Lordship.
what it shows, what it said.
So telephonic conversation clearly reflects that he's saying that don't write all this sort of language regarding not recommendation. It will create problem, Lordship. If your Lordship sees the
Now
statement of
it only says that you
don't write,
but
don't write. You don't write
But
this kind of word. It
from
will create-
where we will find out, we will come to the conclusion that Alok Kumar said to the
authorities engineer
authority engineer
from
that
just telephonic conversation.
show me.
I have shown already, Lordship. For
That put up this on
no,
6/6.
no date has been mentioned. He simply told over phone that don't write such language in your letter. It may create problem. That is the direction given from regional office. I mean to say this accused petitioner. He directly called the authority. Authorities in a completely independent authority, Lordship. How he can dictate, Lordship, don't write such and such thing. He cannot dictate, Lordship. But why he is dictating, Lordship? There must be something, Lordship. Therefore, inference can be drawn from those telephonic conversations which are intercepted during investigation. On the
No,
basis,
but it
on the,
would be only assumption that
no, now, Lordship, prima facie, whether we can hold or not, Lordship. The law is very clear with regard to discharge. Prima facie, whether material available on record gives a suspicion that the offense has been made out against this accused person or not. Allegation, if your Lordship sees the telephonic conversation and the reading of the FIR as well as charge sheet, clearly reflect, Lordship, that this accused person in connivance with all the officials is helping to pass the bills, the bank guarantee, everything, Lordship. And the reason behind is that he is also taking illegal advantage, undue advantage. And the undue advantage in this case is that he got his job secured for his cousin first. Secondly, Lordship, regarding the DM plan, Lordship. DM plan, Lordship, if your Lordship see the statement of the witnesses, Biswajyoti, no, not Biswajyoti, Lordship. Biswajyoti law firm. No, not Biswajyoti law firm, project director. Rakesh Kumar Sharma, page 24, Lordship,
Of your.
of my documents, Lordship, relied upon documents, evidence. 24, page 24. Page 25 is the relevant. I'm taking your Lordship directly to the point. Page number 25.
Yes.
Page number 25, second para, last part, Lordship. Second para, last part. Paragraph is very big, last part, Lordship. But Sri Ashok Kumar, Alok Kumar, if your Lordship got it. Second para,
Yes.
but Sri Alok Kumar asks me that I have to pay him at least 50,000 as a reward for arrangement of DM plan, so and so, along with containers on reasonable from GR info. At that time, he did not committed anything to Alok Kumar, so he did not commit it. This is very important also. There's a clear demand made by Alok Kumar. He has no role to play to sell this DM plan. He is not an agent of GR infrastructure, but the statement of this witness clearly shows he is working as an agent. He is a regional officer, Lordship, the head of a department of a particular region, Lordship.
This DM plan belong to
GR,
NHA.
GR infrastructure. Had it been of NHI, matter would be different, Lordship. GR infrastructure. These DM plans belong to GR. Reasonable
If
from
it is of GR infrastructure, which is the contractor,
Lordship.
then how Alok Kumar will.
That is what our allegation is, that, Lordship. He is hand in glove with that company, Lordship.
No, but he is not the
He
authority.
is not the authorized. That is what I'm. Our
Suppose somebody says that A says that I will sell property of C,
Lordship,
over which he does not have any control.
no control.
So merely by saying.
But
whether
he has
com-
control. Therefore, he's doing his statement like this, Lordship. He has control. From his statement, what it reflects, Lordship, is that he has control. He has control. Therefore, he is getting the job of his cousin. He has control. He is helping out the company. Therefore, he is taking it guarantee, Lordship, that I can sell it. And Lordship, if your Lordship sees the conversation between all these accused persons, accused employees of GR and Alok Kumar, employees of the NH Highway
In
Authority,
your earlier submissions, you have marked the conversation.
Lordship, I have marked.
Yes, proceed.
Lordship. I'm reading the judgment, Lordship. In the background of the law laid down in the context, the contention whether prior approval as contemplated under section 17A introduced by the 2018 amendment.
This is Kerala High Court judgment.
Yes, Lordship. Amendment to the Prevention of Corruption Act is required in respect of every act which form subject matter of the prosecution has to be considered. In this context, it is essential to refer to the exact wording above. The section has been elaborated. Quote paragraph, under section 17A, which was inserted by the Act of 16 of 2018 and which came into force with effect from 2018, the previous approval by the concerned authority is essential. The crucial fact that arises from the consideration in this proceeding is whether previous approval from the competent authority need to be obtained for every inquiry or investigation into every offense committed by the public. The crux of the issue is whether the above provision is omnibus as pervasive prerequisite for every inquiry or investigation into every act done by the public servant in discharge of his official duty. Para 14. No doubt section 197(1) CRPC and section 17A of PC Act operates in two different fields and it is distinct situation. Apparently, it has nothing in common at all. However, consistent principle laid down by the decision referred to supra in relation to any offense committed by the public servant, while acting or purporting to act in discharge of his official duty can be profitably adverted to answer the legal issue involved in relation to section 17A of the PC Act. The decision
Okay.
referred.
Pause for a minute.
Lordship.
In what kind of offenses
Lordship.
the 17A
Will be applicable.
will be applicable?
Lordship. if suppose government call for a tender and different tenders participated, and out of nowhere, a decision has been taken by a committee headed by so and so, that we have taken a decision to award the contract in that case.
But that is not an offense.
That is offer.
In lieu of
In
something,
lieu of some,
there also if you are
Bribe.
taking bribe,
yes, bribe will be there.
then how will you differentiate that case with the present case?
Here the decision has been taken, but here no decision,
Here, whether releasing of bank, for releasing of bank guarantee
lordship.
and for releasing of bills.
Ah.
These are not decision by the
If it-
author.
Therefore, I'm already made my submission. If those things are decision, then every case which are being tried by the trial court will go lordship. Because every act will amount to a decision lordship. Passing of a bill,
No,
is not-
no, if it does not,
passing of a bill lordship is not a decision taken by a particular person lordship. It has to go through various stage lordship. Bill has to be passed not by a single authority lordship. Likewise lordship, bank guarantee also, it is not a single authority lordship. It has to pass to various of table lordship. So therefore, their lordship, we cannot say that it's a decision taken by a particular office lordship, particular table lordship. If you take like that as a decision lordship, then Anand Kumar will also be held liable lordship, because Anand Kumar also has, but we have found nothing against Anand Kumar, who is a project director lordship. There is no telephonic conversation lordship, no intercepted call lordship. And it is clearly mentioned lordship. The decision referred to supra are based on principle that the commission of crimes by a public servant which had no connection with his officiality cannot be considered as one within the scope of section 197 CRPC. Extending the principle to section 17A of PC Act, it can be said that offense like misappropriation, falsification of account, cheating, criminal breach of trust, receiving bribe, etc. are beyond the scope of the provision. So here it is clearly mentioned. And lordship, one more para lordship, para 24. The legal principle involved by has been correctly appreciated by Delhi High Court. It was reiterated that the scope of section 17A was that an approval under section 17A for conducting any inquiry or investigation was warranted only when the act done by the accused, which he was charged of, was relatable to the decision taken or a recommendation made. If the offense was not relatable to a decision or recommendation, prior approval under section 17A has not been required. Hence, any commission of offense or allegation of an act of public servant which is expressly a criminal or constitute an offense, or even demanding illegal gratification or receiving of it, either to routinely move the file or keep the file pending without any decision being taken therein, will not fall within the scope of section 17A. So here also lordship, moving of the file one table to another, it cannot be regarded as no. Hence, prior approval under section 17A is not warranted in such case lordship.
give that judgment.
Lordship, data part lordship, I am relying upon one more judgment of Honorable Supreme Court. This is 1966, one SRC, or the lordship can take AIR 1996 SC 220. AIR 1996 SC 220. This is lordship Bejnath appellant GB Kale versus State of Madhya Pradesh. Here lordship, only one thing lordship, relying para 6. Now the only question is whether in respect of charge under section 409 of Indian Penal Code, Gupta can be said to have been accused of any offense alleged to have been committed by him while acting or perpetrating to act in the discharge of his officially. It is said on behalf of the prosecution that in respect of an offense of criminal breach of trust, no sanction is necessary as the offense can never be said to be committed because it is no part of an official duty of public servant to misappropriate money of his employer. So it's not that relevant. Even then, okay. Here the act complained of this public servant with the discharge of his official duty. Here also the act complaint. What is the act complained of? The act complained of is that of the accused is with regard to pursuing the bills and lordship bank guarantee and demanding bribe in the sense of lordship undue advantage for securing his job and directly lordship for selling of the DM plan. Those acts cannot be regarded as an act done in discharge of his official duty. In section 17A, the intention of the legislature is to protect the public servant who are genuinely working lordship in their office. It is like an umbrella. It is not for a corrupt official lordship who is misusing his office in order to get undue advantage of it. And lordship Devendra Singh lordship, a very good judgment on act done in discharge of his official duty. All the citation of Honorable Apex Court has been discussed, lordship.
Give
What?
the citation.
Yes, lordship. Devendra Singh and others, lordship. This is and lordship.
You have marked the paragraphs.
No, lordship. I could not, lordship, earmark because all the paragraphs are important, lordship.
Okay.
In all, lordship, all the judgment of Honorable Supreme Court has been discussed with regard to the act done by a public
What is the
servant.
citation?
Citation is 2016-12 SCC. 2016-12 SCC, page 86. This does not relate directly to section 17A, but the principle is same, lordship. Principle with regard to the act done. Which act can be regarded as the act done in discharge of its official duty? That has been narrated, lordship, by Honorable Supreme Court. Now, one more judgment, lordship, 2007 1 SCC, Prakash Singh Badal. I bought a different judgment, lordship. My video has page. I'll give it, lordship, subsequently. Prakash Singh Badal, 2007 1 SCC. Page number I forgot, lordship. It was something else has come in my hand, lordship. There also, lordship, taking of illegal gratification has been clearly, division bench of Honorable Apex Court held that taking of illegal gratification cannot be said to be an act done in discharge of his official duty. In that judgment, lordship, 2007 1 SCC, page number I forgot, lordship. It is 9.
Okay.
I'll give that page number also and site. I'll give, lordship. And now, lordship, with regard to 482, I'll place two judgment, lordship. Recent judgment, lordship. Supreme today, lordship.
Name of parties.
Parties is, lordship, Saranya versus Bharati, SARANYA, appellant. SARANYA is the appellant versus Bharati, BHARATHI, Bharati and others, respondent. The power of High Court has been given. I'll simply read the head note, lordship, because it's a very long judgment.
What is relevant for you?
High Court has evidently ignored what has emerged during the course of investigation. The High Court has entered into appreciation of evidence and considered whether on the basis of evidence accused is likely to be convicted or not, which as such is not permissible at all at this stage, while considering application under section 482 CRPC. High Court was not as such conducting trial and what was exercising jurisdiction as an appellate court against order of conviction or acquittal. High Court ought not have to quash charge sheet respond number 1, wherein original accused number 2 impugn judgment and order passed by another. So this is the power of High Court. Same line, lordship, same Honorable Chief Justice, now sitting Chief Justice of Honorable Supreme Court has, along with Justice M.R. Saha, as far as this judgment, lordship. Here also, lordship, same. regarding crossing, the High Court has failed to appreciate and consider facts that there are very serious tribal issues, allegations which are required to be done into and considered at the time of trial. High Court has lost sight of crucial aspects which have emerged during course of investigation. High Court has exceeded its jurisdiction in quashing criminal proceeding exercise of power under section 482. Complainant has not placed on record power of attorney so and so. Original complaint has not been looked at. Impugned judgment order passed by so and so has been. This is another judgment.
What is the citation?
Citation is lordship KAPT and Kaptan Singh, appellant, Kaptan Singh versus State of Uttar Pradesh and others. High Court cannot go into the merit of the case. Here it is. Para. The head note, lordship, some paras has been mentioned. Para 10, I think, in that case, in that citation. And lordship, this Niharika infrastructure, your lordship has come across, I think. Niharika Infrastructure Private Limited versus State of Maharashtra. That is also Supreme today, 2021.
Which para you are relying?
Lordship para 10, 15 and 22, 23. Niharika. 10, 15 and 23. In head note, lordship, may I read next? Court is not required to consider on merit whether or not merit of allegation made out a cognizable offense, and court has to permit investigation agency police to investigate allegation in FIR. Such parameter would be applicable and oblique or such aspects are required to be considered by High Court while passing an interim order in quashing petition in exercise of power under section 482 and oblique or not under section so and so. However, an interim order of stay of investigation during pendency of quashing petition can be passed in circumspection. Such an interim order should not require to be passed routinely, casually, or mechanically. Normally, when investigation is in progress and facts are hazy and entire evidence material is not before the High Court, High Court should refrain itself from passing interim order of not arrest or to coercive step to be adopted, and the accused should be relegated to apply for anticipatory bail. The High Court shall not, and as such, is not justified in passing order of not to arrest so and so and so. Lastly, lordship, High Court has to give brief reason why such an interim order is warranted and oblique or is required to pass so that it can demonstrate application of mind by court, and higher forum can consider what was weighed with the High Court while passing such an interim order. Thus, stop. Whenever interim order is passed, the High Court no coercive steps. High Court must clarify what does it mean by coercive steps to be adopted, as the term coercive steps to be adopted said to have two verbs and so and so. Regarding, I think this is not applicable. It is
Okay. No, if it is not required,
not required.
if you are relying on a specific observation of
Lordship, again here 482, it is written,
the
but
powers are discussed,
powers are
but there are many guidelines.
lordship,
Which specific guidelines favor you?
lordship,
You can mark it later on. You can give it to me later on.
lordship, lordship. So lordship, I'm summing up lordship, regarding this case lordship. And lordship, one more citation I have relied upon regarding that. Bhajan Lal lordship. Bhajan Lal I am relying. The guideline which has been laid down in Bhajan Lal,
Which one?
all the guidelines lordship regarding 7 guidelines has been framed, which are though not exhaustive, Lordship. It's a myriad kind, Lordship. 7 guidelines has been laid by Honorable Supreme Court regarding passing of FIR and charge sheet, Lordship. These 7 guidelines are not at all, Lordship, are fitted in this case, Lordship.
None of the guideline fits.
Lordship,
Petitioner's case fits in
does not
under,
fit
under any of the guidelines.
any of the guidelines. But I'm only placing the relevant portion, Lordship, the guidelines and the citation. Only. It's a very voluminous again, Lordship. I have only placed the relevant para, Lordship, which I relied. Only 2 pages I have relied. So therefore, Lordship, that the petition filed by the petitioner should be liable to be dismissed.
Your brief arguments in written is
I have given.
you have
Lordship.
submitted. no?
Yes, Lordship. Along with the relevant materials which we have relied upon.
My lord, I will need 2 minutes only because my learned friend has made 2 to 3 factual incorrect statement, my lord, that I wish to draw kind attention of, and which is duly reflected in the material or the reply filed by them.
What factually incorrect?
One is, my lord, he says that passing of bill, I had any role. If my lord will have their reply, passing of the bill, I have nothing to do with it, my lord.
Okay.
I had a role to play as far as the bank guarantee, release of bank guarantee is concerned, because that is, I am the competent authority to order release of bank guarantee. However, deciding authority. However, as far as passing of the bill is concerned, my lord, it is their own reply if my lord will have, not our contention, my lord. If my lord will have page number 535.
Yes.
535, my lord, para number 16.
What it says?
It
Procedure.
says, my lord,
Procedure of passing of the bill.
payments were made by project director and then, my lord, by finance and account department.
And the
Was
petition
made in the
does not have
NHI office
involvement.
and approval of the project director for making payments, and therefore, and I have no role.
Okay.
So they, and in the same para, the further says the approval of regional officer, that is petitioner before my lord, NHI officer Guwahati was required for the release of bank guarantee security to any of the contractor. So I had any role to play as far as release of bank guarantee is concerned. As far as the bill, running bill or any bill is concerned, I am not the authority, my lord. So that is the incorrect statement. Then my learned friend has made that that the 2 persons of NHI officers who were arrested allegedly taking bribe had named me, my lord. That is absolutely incorrect statement. I rely on the document, their own document, which is, my lord, recovery memo. That is on page number 624. That is the tribe memo prepared by them. That is their own document. Furthermore, my lord, in para number 18 on page number 536.
Yes.
536, my lord, para number 18. It is specifically mentioned that the officers who were arrested took their money for themselves. If my lord, if I may be allowed to read, my lord.
Yes.
That the deponent begs to state that what is the written on page number 536, my lord. That the deponent begs to state that during the trap proceedings on being caught and intercepted by CBI team, accused Shri Manoj Kumar, Junior Account Officer, NHI Guwahati, disclosed in the immediate presence of the independent witnesses that out of the bribe amount of rupees 4 lakhs, which he has which he accepted as illegal gratification, rupees 3.3 lakh 50,000 rupees is the share of accused Deepak Das, account officer, NHI Guwahati, and he will keep only 50,000 rupees as his share. On this, accused Shri Manoj Kumar was made to talk to accused Deepak Das over phone by keeping the mobile on loudspeaker mode, and during such call, the accused Deepak Das asked co-accused Shri Manoj Kumar to deliver his share of rupees 3,50,000 rupees at a place near to the home of the accused Deepak Das. On this, Shri Manoj Kumar, along with the CBI team members, including independent witnesses, visited area near to the house of accused Deepak Das, and during it, Shri Manoj Kumar had handed over the envelope containing rupees 3,50,000 rupees to Shri Deepak Das, and Shri Deepak Das accepted the same as his share of rupees 3,50,000 in cumulative bribe amount of rupees 4 lakhs. All these proceedings took place in the immediate presence of the independent witnesses. So my learned friend, it do not hold good that my learned friend says that I was also taking share or anything in this regard. So that is, I expect not to make such statement.
I'm sorry, Lordship, I would like to understand this case, Lordship. I have stated regarding the statement after apprehending this accused, they made statement in
No,
this case. I'm not saying this is a
No, no.
trap.
My dear
Here,
friend,
only the amount of 4 lakhs has been discussed.
my learned friend has not
During investigation, this accused person made statement.
Is
That
it
is-
before us?
No, Lordship, it is there in CD, Lordship.
he never placed on record.
Verify.
From the IO's information, Lordship, I came to knowledge.
But how can I verify?
Then, Lordship, I'll have to again bring the CD.
That is absolutely wrong statement
Right,
made.
Lordship. If this honorable court direct, I'll produce the CD. Lordship.
No, if you are relying on that, it would be.
See, Lordship, for trial, statement of accused is irrelevant, but for this,
No. The two person who were apprehended in trap,
trap, Lordship. This amount is different, Lordship. This amount during trap, I'm not disputing with regard to this amount. But when they were interrogated, Lordship, by police, they stated that Alok Kumar is also involved. This is one incident, one day incident, Lordship. It is continuing for last so many days, Lordship. They were apprehended with regard to a single day on demanding on Lordship, giving the money 4 lakhs rupees to them on that day, they were trapped. But it is not, this is not the only amount.
no,
It's
but
continuing, Lordship.
the investigation in a criminal case has
I
to be
understand. I understand.
against a specific allegation.
Lordship. Therefore, I'm not disputing this fact, Lordship. I'm not stating, Lordship, this amount has been, he is a share. I am stating that when these accused person were arrested, they made a disclosure before the IO that Alok Kumar also used to take. Share also he used to take with regard to passing of the bill and all. I'm not saying about this amount, Lordship. My learned friend, perhaps, and I'm just making a statement, Lordship. If Lordship direct me, I'll produce the CD.
Para number,
And it's a Lordship trap
para,
case.
para number 17 also.
It is not only one day we have trap and game is over, Lordship. Calls were intercepted from very earlier. On this,
When can you produce the case diary?
Lordship, from Delhi, it will have to come.
Okay.
That is never ending process. Matter is in reply, they have not mentioned. Now they come up with this new version because there is no evidence, because they are taking somersault. CBI is taking different stand at different
No, I'm
times.
clear, Lordship. I am making my submission, whatever documents is there, Lordship. I am making my
No,
submission.
okay. Let us conclude the hearing, but I think I have to peruse the case diary.
Lordship.
Yes. No difficulty, my lord. No difficulty at all, my lord. Then, my lord, on para number 17 also, it is specifically mentioned in their reply on page number 536 that the regional office at Shillong was competent to make the payments of the running bill, and the regional office petitioner before my lord was competent to release the bank guarantee, respectively, take the decision regarding releasing the bank guarantee. That is also,
That you have already.
it was in two separate paras, my lord, it is so stated.
That you have yesterday submitted.
Yes, no, I was just reading the reply that filed by CBI, and now they say that I was instrumental into release of bills, payment of bills, but it is not so stated in even their charge sheet. Charge sheet is a matter of record, my lord, that I have already appended with my petition.
You have to produce the case.
Not sure.
When will you produce it?
I'll let the court know, but I'll have to talk lordship with the IO, let him come.
15 days?
Yes, after 15 days, lordship, we need, on 15, I'll be out of session from 6 to 12. On 15, lordship.
After 18th, I'll be.
18, let, on 18.
18th.
Okay.
Okay. Heard the reply of Mr. M. Haloy, learned Special Public Prosecutor, CBI, as well as clarifications given by Mr. S. Mann, learned counsel for the petition. The hearing of the parties is concluded. However, during the course of hearing, it was certain submissions were made by learned Special Public Prosecutor, CBI, for which perusal of the case diary is felt necessary. Hence, learned Special Public Prosecutor is requested to produce the case diary on 18th February before this court. 18th March before this court. Let this case be listed again on 18th March.
Grateful.
I can reserve the judgment and
Yes,
there. Oh, no, on
After perusal of the.
let it come. Let it come on
Lordship, go through the case diary and then.
18th March. As parts admitted. Hearing concluded, only I will go through the case diary.
right, my lord.
Yes, I was saying.
Item number 11.
Earlier.
Earlier this was rejected.
Yes, my lord.
When?
It was rejected, my lord. On 20/07/2023. Hereafter, another bill.
Case diary is there.
Diary is here, my lord, up to 2/10/23. 2/10/23.
Why it was rejected?
Rejected, my lord.
It is under section 326 and 307.
What is the new ground?
New grounds, my lord. I have annexed some medical documents, my lord. And the father of the petitioner also suffering from some illness, my lord. He is a doctor, my lord. And he is the only son, my lord. And now he is absconding, my lord, only because my lord told the family is suffering, my lord. And it is a case of physical assault, my lord. And as per my information, my lord, the victim, my lord, admitted in the hospital, and on the very day, my lord, he was released, my lord. My lord, medical report also received, my lord. So if succeeded, my lord, I will pay the trial, my lord. I am the local boy, my lord. And
Now, why charge sheet is not filed?
That is, diary is not up to date, my lord, so I cannot say, my lord, why not file? Because he has not been arrested, my lord, that may be one of the reason, my lord.
custodial interrogation, my lord, necessary only because to unearth the truth and to recover something, my lord. But in this case, my lord, everything has been examined, my lord. And only my lord, arrest is left, my lord. So for the allegation is concerned, my lord, allegation is not a serious offense, my lord. I admit, my lord. But Thing is that, my lord, whether my arrest is necessary for the purpose of investigation.
No, you commit a serious offense and then escape from police, led the investigation.
Yes, my
What
lord.
are the principles?
The date of, my lord, date of FIR, my lord, 26/4/2023, my lord. And today is, my lord, 29, my lord. 2024, my lord. Almost, my lord,
Very,
11 months.
what are the new grounds mentioned? Which
New
there are-
ground, my lord.
It's medical.
Yes. Page 16, my lord. He is also, my lord, got injury, my lord, in an accident, my lord. All united fracture noted in the shaft of tibia and fibula, metallic intramedullary vein seen across tibia, bones with no lens. This is page 19, my lord.
What else?
And, my lord, page 20, my lord. Father of the petitioner, my lord, which way that person, my lord. The only one, page 20 and 21. The other documents.
Okay, you give me the case then.
Yes.
Heard Mr. P and counsel for the petitioner. Also heard Mr. V.B. Gogoi learned addition. What is your submission, Mr. Gogoi?
My lord, that injury report is here, my lord, that previous injury. That is 3 days he was hospitalized, thereafter released, my lord, that is.
Also heard Mr. B.B.
Now he is cured, my lord.
Now he is.
Counsel for the learned additional public prosecutor. Let this case be fixed for delivery of orders tomorrow, that is 1st of March. Tomorrow I will pass.
Development.